Seek your Lordship indulgence. Lordship, part 2, item number 10 and 11. Though it was earlier mentioned to have a hearing on today, Lordship,
what
I have
happened?
part heart matters at courtroom number 1, Lordship. That it may take time. So I seek your Lordship indulgence.
Okay,
Let's.
see if you would be available tomorrow.
Uh,
Do you
Well,
think it's possible tomorrow?
Tomorrow I'm having difficulties myself, but
So,
if it is possible,
Next week.
Monday, my lord. 16.
on the submission made by the learned counsels for both the parties, list on 16th,
16, my lord.
16th 6 2025.
My lord.
And your Lordship, part 2, item number 4, the same party, we are same party, Lordship. It may be taken up after a week, Lordship.
Both the parties,
My lord.
on the submission made by the learned counsels for both the parties, list after 1 week.
Obliged.
Please, Your Lordship, Madam. In respect of this part 2, item number 7, my learned friend is there for the respondent. If the matter may be taken up after a week, if possible.
Both the parties, counsels are present. Private. Most probably, counsel for respondent number 1 will be the private respondent.
My lord.
On the submission
My lord,
made by
if
the
possible next week.
learned counsels for both the parties, list this matter in the next week.
okay.
Anytime next week. you
Anytime
can
next week. Anytime
Agree on a date.
Similarly, I'm afraid I'll have to mention this item number 8 as well.
8.
My learned friend is there for
Both
the
of them are
state.
there?
Yes, Your Lordship.
Okay, next week?
Yes, Your Lordship.
Okay. Same in the next week.
Deeply obliged.
Much obliged, Lordship.
Your Lordship, may I kindly make a mention regarding item 1 of part 2. This may be taken up tomorrow, my lord.
Part 2.
Yes. Or
Item number?
item number 1, or if not possible, next week also, my lord.
Okay, hearing
Yes.
list. So it can be held tomorrow. See, the trouble is when we have 3 courts functioning, we don't
Yes.
have enough counsels. See if you can both be present tomorrow.
Yes, Your Lordship.
Okay, if not, we can list in the next week, but make an attempt for tomorrow.
My lord. Much obliged.
May I kindly take your Lordship indulgence in making mentioning of item 5, part 2.
Item 5, part
Part two.
2, yes.
My senior is the learner makers in this matter.
Yes.
So, Your Lordship, if Your Lordship may allow this matter to be listed next week.
Okay. Now, what about the other side? Have you taken the consent?
Yes,
When you
ma'am.
pray for adjournment, make sure that the other side is also aware of the adjournment. Okay. Have you taken the consent?
Yes, my lord.
Yes? Okay. Mention is made on behalf of Mr. J.C. Lalnunsanga, learned amicus curiae, for adjournment of the matter with the consent from the other side. In view of the above, list in the next week.
Lordship, I would like to seek indulgence on mentioning part 2, item number 6. And my senior, the main counselor, she is having some personal problem, and I have already taken the consent of the other parties. And
have taken?
if it is
Okay.
possible, may this matter be listed after 2 weeks?
So after 2 weeks, consent from the other side?
Yes, Your Lordship.
Mention is made on behalf of Ms. Jacinta, is it? So
Yes, Your Lordship.
learned counsel for the petitioner for adjournment of the matter with the consent from the other side.
Like,
In view of the above, list after 2 weeks. Okay, 2 weeks.
For motion, item number 1.
Your Lordship,
Yes.
this is a contempt petition, Your Lordship, filed by the petitioners against the respondents for the willful and deliberate defiance of this honorable court's order, which was made on the 21st of November 2024 in WBC number 60 of 2023, Your Lordship, wherein a direction was made by this honorable court to the respondents in 3 respective points, Your Lordship. The first is that the respondent authorities were to refund the 10% tax deducted from the compensation amount of the petitioners, Your Lordship. And the second is that they were directed to reassess interest payable under Section 80 of the RFCTLARR Act, Your Lordship. And also the BRTF officials were directed to deposit the excess amount before the collector within a period of 2 months, Your Lordship. And the third is that the state respondents were also directed to establish land acquisition, rehabilitation, and resettlement authority within a period of 3 months, Your Lordship, after receipt of the certified copy of the order, Your Lordship. And a certified copy of the judgment and order was served, and they were duly received on December 1st week, Your Lordship.
Where's that? Where's that?
It's in page 47, Your Lordship. And I should tell you.
47?
Yes. Page 47 to page 50, Your Lordship.
47 is a letter
Yes, Your Lordship.
addressed to the Mara Autonomous.
And
But,
the Deputy
where's
Commissioner.
the, how can you say it was received on December?
Your
Where's
Lordship,
it?
it's on the left corner,
Left corner?
stamped, Your Lordship. DCC.
Okay, yes. Oh.
And the next annexure, which is page 49, is the Secretary to the Government of Mizoram, received on the bottom left.
Okay, we'll issue notice, let's see. Heard, Miss
K. Venetia.
K. Venetia, Learned Counsel for the petitioner, who has filed the instant petition under Rule 9 of the Contempt of Court, within brackets, Guwahati High Court, close bracket, rules, comma, 1977, read with Section 12 of the Contempt of Courts Act. You have missed the S, okay, Courts Act, comma, 1971, for non-compliance of the judgment of this court dated 21/11/2024, passed in WPC number 60/2023. In spite of receiving copy of the judgment and order by the respondent number, page 47 is respondent number.
Respondent number
Counsel?
4 and 5, Your Lordship.
47, okay. In spite of the respondent number 4 and 5 receiving copy of the judgment and order on 9/12/2024, and the respondent number, state government is,
That's for respondent number 3, Your Lordship.
and the respondent number 3 receiving the copy of the judgment and order on 02/12/2024, wherein the learned trial court, wherein the learned court had given directions to the respondents to comply with the said judgment and order within 2 months and within 3 months of the receipt of the certified copy respectively. Then, full stop, then you better notice be issued to the respondents. Ms. Lalmunpuri? No, you cannot, this is contempt. To the respondents to registered post with AD within 3 days, returnable by 3 weeks. List after 3 weeks.
Obliged.
Warrenson, item number 2.
Lordship, with due respect, I have informed the other parties also. I'm seeking leave of this honorable court for filing rejoinder affidavit to the counter filed by the private respondent.
Yes, okay. Heard Mr. J.C. Lanunsanga, learned counsel for the petitioner, who prayed that he may be allowed to file counter affidavit, reply
Rejoinder.
affidavit to the, rejoinder affidavit to the affidavit in opposition filed by respondent
Number 5,
Number 5. Praise allowed.
3 weeks.
List after 3 weeks.
Much obliged, Lordship.
Item 3.
Yes.
May it please, Your Lordship. My Lord, in this case, we have some difficulties in finding out the address of some of the respondents. Notice is yet to be completed in respect of 2, 3, 4, and 5.
Ah,
As far as 4 and 5 is concerned, if I may be allowed to take steps by way of a registered post again, especially considering the fact that,
where's his address? 5, you don't want dusty mode?
my Lord,
You don't want to serve notice through dusty?
they're not, as far as respondent number 2 is concerned, as per our information, he has been arrested in some money fraud case in Arunachal.
Okay. So
3,
respondent number 5,
4 and 5.
one is in Tui Kuat Lang, isn't it? 5 is Tui Kuat Lang.
No, my Lord, 5 is in Mumbai. 4 and 5 are in Mumbai.
Okay, these are the petitioners. Okay, fine. Then fresh notice.
4 and 5, I think we can take steps again because in respect of 6, ID card was returned duly served and the address is exactly the same. I don't know why it didn't reach.
So fresh steps. Is it?
Yes, in respect of 4 and 5,
Yet to remove from 4 and 5. Okay. 4 and 5.
now 2 is arrested in,
1. So 1 is complete.
the rest are completed.
Okay,
It's
2
only-
to 5. Issue
Yes.
notice to respondents number 2 to 5 as directed. So 2 to 5 you had issued notice.
Yes,
Now office note shows that see office note 15 5 2025. Okay. The learned counsel is to take necessary steps for respondent number 2 and 2 to 5. Okay. But learned counsel for the petitioner took steps for service of notice upon respondents number 4 and 5 only. What about 2 and 3?
like I was mentioning, Your Lordship, 2 has, as per our information from the police, is that 2 has been arrested in a money fraud case in Arunachal Pradesh.
Then some written this thing has to be there.
That's what,
Okay.
we're trying to get some kind of
2.
acknowledgement.
And then what about 3?
3, we cannot locate his address. He was not represented even in the lower court.
So is he just a pro forma
He's a proper party, my lord. That's the
proper?
problem.
Then through newspaper publication maybe. What's his address?
It's Kamrup,
3?
Kamrup, Assam.
Some steps at least you have to take. If you can't find him in his address, or you make an attempt to find out his proper address.
We shall, my lord.
You make an attempt. If you can't, at least in some newspaper publication, Sam, then you can say that it's complete.
We can do that, my lord.
No?
We will try for newspaper.
So you want to do it through newspaper or try and locate his address?
I'd rather prefer newspaper if possible.
Okay. Heard Mr. Alfakoma, learned counsel for the appellant, who submits that notice upon respondent number 2 and 3 could not be served since he has been informed that respondent number 2 is at present in the district jail. Is it?
My lord.
In connection with some other case.
In Arunachal.
In your case?
In Arunachal case.
Okay.
In different cases.
So where is he now? In which jail? District
believe
jail, Aizawl or some?
Itanagar.
Itanagar. Then you have to get.
So it's a bit
okay,
difficult to get
yes,
that some
yes.
kind
Okay,
of.
he has a verbal information.
Yes.
Okay, that the respondent number 2 is at present in custody in a jail in Itanagar. He prayed that he may be allowed to get the documents to support the same. The learned counsel also submits that notice to respondent number 3 may be allowed to be served through newspaper publication since his proper address is not known and that he had also failed to appear before the learned trial court. In view of the above, the learned counsel may take steps for service of notice upon respondent number 3 through newspaper publication in the district where he is said to be residing. Then 4 and 5, what did you say for 4 and 5?
4 and 5 are pro forma, and I don't exactly know why, because their address is exactly the
Okay,
same as
so,
6 and 7.
Okay, the learned counsel for the petition, appellant, okay, is also allowed to take fresh steps upon respondent number 4 and 5
Through registry.
through registered post with AD within 3 days.
Mine.
List after 3 weeks.
Deeply obliged.
Wait, we have to fix a date for newspaper publication, isn't it? After 3 weeks on for their appearance. 3 weeks on, give me a date. 3 weeks. 1, 2, 3. July,
July first week, my lord, anytime.
the first week is a holiday. 17. On 17/7. It said 17/7, let's see what happens. Okay, on 17/7/2025.
Item 4.
Okay, whoever I mentioned petitioner, make it appellant.
In item 4, Your Lordship, in the last court date, my learned friend for the respondent had taken time to file their written objections.
Yes, Your Lordship, we will be filing a counter affidavit during the course of the day.
Okay. Mr. Zalpakoma, learned counsel for the appellant is present along with Miss
Lilian Puikyangte.
Lalian Puikyangte, learned counsel for the sole respondent. The learned counsel for the sole respondent has prayed for time to file the counter affidavit. No,
Written
submits that they will be filing their written objection within the course of the day.
Yes, Your Lordship.
In view of the above, list after 1 week.
My lord. Obliged.
Item 5.
May it please, Your Lordship?
Oh, first time it's coming up. Yes.
No, yes, my lord. This is an appeal against an impugn order passed in eviction suit and its consequential order passed in execution. So, my lord, in this eviction case, my main grounds of appeal is that the learned trial court has exceeded its jurisdiction in cancelling the appellant's LSC without even giving opportunity to adduce evidence. However, he had directed to conduct a spot verification, and this spot verification was submitted before the learned trial court, and only based on that spot verification report, he was of the view that the appellant's LSC is liable to be cancelled and is a void ab initio. And then he further directed the appellant to vacate the suit property within 3 months.
Okay, now concerning the spot verification, the person who conducted the spot verification, was
Yes.
his evidence taken in the court?
No, no, my lord. That is my main ground of appeal.
Okay, we'll see. We heard Miss
H. Lerosang.
H. Ramsani, learned counsel for the appellant who has filed the instant appeal under section 17 within brackets 2 within brackets small b of the Mizoram Civil Courts Act, 2005, read with section 96 Civil Procedure Code, 1908, against the impugned judgment, impugned order dated 25/07/2024, passed by the Learned Court of Civil Judge, within brackets, Senior Division, close bracket, -2, Aizawl District, Aizawl, in eviction suit number 3 of 2023. Full stop. The Learned Counsel submits that the Learned Trial Court had erred in passing the instant order against the appellant without giving the opportunity to the appellant to adduce the evidence and also adduce evidence. Full stop. Appeal is admitted. Issue notice to the respondent. Full stop. Are you representing the respondent?
Yes, Lordship.
Mr.
K. Kham Thian Manga.
K. Tam Thian Manga accepts notice on behalf of the sole respondent. Full stop. No need to issue formal notice. Requisite copies of the appeal memo to be duly furnished to the learned counsel for the respondent. LCR, is it required to be called for?
No, my lord, because I have annexed all the written statement and the plaint in my appeal petition.
Okay. Now, since both the parties are the same, we can list it for hearing in the next date.
Yes, Lordship.
Yes, your lordship. And then one thing, interlocutory application that is praying for staying of this impugned order has been filed.
Now, in the same RFA, since both the parties are duly represented and it is submitted at the bar that LCR would not be required in the instant case, this court finds that the matter may be listed for hearing in due course as per its own term. So, now, in the IA, heard Ms. So-and-so, learned counsel for the applicant who has filed the instant application under Order 41, Rule 5, Civil Procedure Code for the stay of the impugned order dated 25/07/2024, passed by the learned civil judge within brackets against senior division close bracket dash Roman 2, comma, Izol in eviction suit number 3 of 2023. Okay, well, now why have you filed this? Say,
This year, sir, my lord. Pardon, your lordship.
what is the reason?
Oh, there is my building covered in that suit property is under lock and key because of that execution filed by the respondent. So there is substantial loss on my part. That is my main ground for stay of application.
Where's the execution order? Nothing is mentioned about an execution case being filed. Eviction suit is there, but what execution?
My lord, the execution application is at page 27.
But you have not mentioned that anywhere. Even in your RFA, have you mentioned that in the RFA?
Yes, your honor.
Where?
At the time of filing my appeal petition, this execution order was not passed. So later,
Okay,
this
so in the
application-
RFA, it's not mentioned.
Yes.
Now, in the IA, where is it?
And page 27. If I may take your lordship to page 28, para 6. If, with your lordship permission, if I may read out. On hearing the learned counsel for the decree holder and also on careful perusal of the documents available on record, this court is of the considered view that it is a fit case to keep the suit property under lock and key for the ends of justice and so as to maintain the sanctity of the and efficacy of the court. Accordingly, it is hereby ordered that the suit property shall be kept under lock and key until further order. So, during this period, I would like to draw your lordship attention that the copy of this execution case is not received by me during this time. And
So if it is kept
on verbal
under lock-
submission of the
if it is kept under lock and key, that means were you residing in this house?
I have a shop, Muaka Tire.
Okay, so this
Yes.
is your shop that is kept
Yes,
under lock
that
and
is
key.
my main source of income. And
So
your
in the
lordship,
RFA, say list after 2 weeks.
And also, Your Lordship, I have an interim prayer in my.
So now in the IA, we'll issue notice first. Okay. So and so, praying for stay of the impugned order passed in so and so. Okay. I think we have mentioned that eviction suit number 3 of 2023. And also for stay of the order dated, which is this one? 3101.
30 January
30
2000.
01 2025 in execution case number 171/2024, wherein the shop of the applicant has been kept under lock and key. The learned counsel submits that by keeping the said shop under lock and key by the impugned order dated 30/01/2025, the applicant is suffering irreparable loss since the shop is his main source of income. Full stop. Issue notice to the opposite party. Mr. So-and-so accepts notice on behalf of the opposite party. Yes, anything to submission on
Yes.
this?
One authority that I would like to deny.
Hearing the submission, nature of submission made by the learned counsel, the, what's this?
At paragraph number 9.
9.
Yes, page number 713. With your lordship permission, if I may read out the relevant portion. Dispossession during the pendency of an appeal of a party in possession is generally considered to be substantial loss to the party applying for stay of execution within the meaning of clause A of sub rule 3 of rule 5 of order 41 of the code.
Anyways, we'll allow till the next date of listing. And then in the meantime, if you want to file any written objection, you can file. When was this order passed? What shop is it?
Tire Works by the name Muakat Tire.
Okay, this court find it fit to consider the IA in the next date of listing. The learned counsel for the opposite party to file their written objection, if any. Yes, we will consider in the next date. It's not as if you're going to, we can make it after 1 week also.
Yes.
List after 1 week. The IA, the RFA also after 1 week. In the next week, we'll
And your
consider
lordship, regarding my interim prayer,
Lordship, may I?
whether to allow interim prayer or not, we'll consider in the next date.
Obliged, Lordship.
Order, item 6.
File a written objection and we'll dispose of the IA in the next court date.
Yes, Lordship.
Yes. So both of RFA and IA next date, next week. After 1 week. Okay, then after 1 week. After 1 week. Yes. Yes, so written objection filed? Filed.
My lord, as far as MPSC is concerned, I have instruction that we can keep it abeyance,
Okay.
subject to the orders of the court. This is what instruction that we are not filing.
So
We just
no
leave it to
written
the
objection,
wisdom of the court.
Okay. Then what about, have you filed a written objection to the IA? This is an IA.
I'm the private respondent in the main writ petition, and I'm the one who filed the IA
seeking for.
Okay.
We had filed the objection, my lord.
Okay.
already.
You have filed your written
Yes,
objection.
my lord. Already.
So in the IA, you're the applicant,
Applicant.
so you stand on the side, the applicant.
Yes.
So you're the main
Yes, my lord.
person who was, so you stand on this side because we're considering
I
the
was
IA.
trying to make submission prior that, my lord. On the last occasion, due to the state respondents have not yet filed the affidavit in the main writ petition. Time was granted. Now pleadings are completed. So instead of concentrating in the IA, we can take up
Okay,
the
you don't
main.
want to press the IA
If the main case is taken up today,
today?
yes, my lord.
No, can we take it up, can this thing, no, it's not been listed for hearing, admission hearing. Have we admitted the matter?
Not yet, my lord.
So we'll admit the matter today and fix a date for hearing. Isn't it?
Yes, my lord. That may be better.
Okay, now in the IA, the learned counsel for the applicant is present and submits that he will not be pressing the IA and instead state that the main writ petition may be disposed of at an early date. Okay. In view of the above, we find it fit that the IA be disposed of along with the writ petition number C of so and so. Okay, may be considered. In view of that, we find that the IA may be considered along with the writ petition number 85 of 2023. Now, in the main writ petition, Mr. So and so, learned counsel for the petitioner is present along with Mr. So and so, learned counsel for private respondents number. Victor is respondent number
6252.
private respondents number 6252, comma, then Mr. JC, this thing is for respondents number
53.
53 and Mrs. Mary L. Kyangde, learned government advocate for respondents number 1 to 4. It is seen that pleadings are complete. And on hearing the learned counsel, this court found it fit to admit the appeal, the writ petition, and matter may be listed for hearing on, give a date, we'll have a hearing. When will all of you be present?
My lord, 17?
That's it.
Okay, on 17th, 6, 2025.
Obliged.
Item number 7.
My lord, in respect of the respondent number 2, there is no return of any card or unserved notice. So if I may be allowed to make service by way of Dusty.
Who is respondent number 2?
Respondent number 2,
I mean, is he here in
Roy Cobb.
this thing? Demobok. Okay. What about the other respondents?
they have been represented, my lord.
All of them you represented?
Yes.
Okay. Mr. Tila Zekima, learned counsel for the appellant is present along with Mr. Ikero Kung, learned counsel for respondents number
1.
1. What about the same? Okay, and Mrs. Mary L. Kyangte, learned government advocate for respondents number 3 to 6. The learned counsel for the appellant has prayed that he may be allowed to serve notice to respondent number 2 through Dusty service since AD card upon respondent number 2 is not returned till date. Praise the Lord. Notice is to be served to respondent number 2 through Dusty mode and affidavit to the effect to be
Lord.
duly filed. List.
Lordship,
after
this
2 weeks. What?
appellant has filed this substitution application in respect of the respondent number 1. But
Already filed?
Yes.
No.
already filed, yeah,
Disposed.
already filed. But substituted, that is corrected, cost title and the
Cost title
petition
not corrected?
not corrected, and the copy is not furnished to me till then.
Okay, anyway, through Dusty mode and affidavit to the effect, okay, then full stop. The learned counsel for respondent
One.
number 1 submits that the respondent number 1 has been substituted. Okay. Void IA number. In IA, must be in IA. In IA, what? When was it? Any attached IA? Wait, I just see.
IS 69 of 2024.
In IA
My
69
lord,
slash.
this is IA number
No, this is
20209.
condonation. This is
Yes.
condonation.
IA 209.
209, sorry.
209 of 2024.
Yes, in IA number 209, 2024. Void order dated 13/01/2025. However, the cost title has not been corrected, is it?
Yes, remain the same.
The learned counsel for the appellant to make necessary corrections in the cost title. And what about the appeal memo? Has it been served to you?
Yes, appeal.
Okay. Necessary corrections in the cost title, and thereafter notice be issued to the respondent number 2. Copy of the corrected cost title is also to be duly furnished to the learned counsels for the respondents. Yes, list after 3 weeks.
Lordship, I am respondent number 1.
Pardon?
Respondent number 1.
1.
Yes.
Noted.
Part 2, item number 2.
May I please, Your Lordship, my lord. The question involved in this appeal is whether the trial court has erred in law and in fact in dismissing the suit without taking evidence of the parties. This is question of law involved in this appeal. My lord, civil suit number 81, 2011 was filed by the appellant and by order dated 25th October 2016, the learned trial court has dismissed the suit without taking evidence. The suit was dismissed by the learned trial court on ground of limitation, but so far as Article 65 of Indian Limitation Act is concerned, the suit is not barred by limitation.
Okay, let's see.
Your Lordship, before we start, I would like to produce
Parties
this.
are represented? No.
Yes, I represent the some of the private respondents.
Okay.
And others, it's deemed served. So, Your Lordship, before we start, I would like to submit this cancellation order, the pass in issue in the case, since there is no stay in the instant appeal. It's issued in the year, it's cancelled in the year 2020. Now, if there is no land pass, because this pertains to the land in Brigade area, because of subsequent transfer, numbers of transfers of ownership.
When if it's cancelled, we can set aside the cancellation order
If the application is made, but not now. There is no challenge to the cancellation order. So I don't think that the rights subsist as of now. Your Lordship.
See, so now, in your appeal, this is in 16 March 2020. What is,
This information is not furnished.
so,
Because they haven't even paid tax for a very, very long time.
so wait, when the, what was the civil suit was filed,
My lord,
this is in 2011.
my lord.
This cancellation order was not in existence. It was still not cancelled, isn't it? Judgment was in 2016.
Yes.
So we'll see this first, because here the 2020 matter will not come up. So if the judgment of the learned trial court is set aside, then evidence, additional, whatever, subsequent cancellation also can be mentioned. But we will first see whether the dismissal order saying that it is barred by limitation is correct or not. Let's see that. So when was this thing? Let's see the judgment.
Page number 13, Annex 2.
13. Okay.
Operative person of which is page number 18. Second last paragraph. Page number 18. Well, may I read?
Yes.
Considering the above appreciation of both sides' submissions, it is crystal clear that law of limitation bar to file suit against some of the defendants who hold LSC issue in the year of 1987 and 85, and from their own submission in CMA number 208 of 2011 arising out of civil suit number 81 to 2011, the present suit is filed after limitation period has already lapsed. Therefore, the court did not find the merit of the proceeding the case as the plaintiff is barred by limitation, period of limitation. Hence, this instant suit cannot be maintained in its present form and style, and the same is dismissed on the above grounds. Period.
So give me some background. What you're having?
Yes.
So tell
Period
me,
pata
why
number-
did the court pass this order?
This pass 758 of 1976 was issued by the respondent number 3 way
Okay.
back in 1976.
1976.
My lord.
To you.
My lord.
So you have a pass. 1987.
My lord.
So what happened to you?
So my land was encroached by the land of the respondent number 4.
then? Okay, appellant was having a pass. Where's the
Yeah.
pass? LSC.
My lord, how periodic pass?
Okay, not okay.
Not
Here it
LSC.
says LSC issued in the year. So it's not LSC, it's periodic pass, is it?
yes, it is.
The court says LSC.
My lord, this is periodic pata.
Okay.
Yes.
So you are having a periodic pata.
Yes, 758 of 1976.
758 of 1976.
My lord.
Well, let's come from the beginning.
Yes.
Because the court does not mention anything about periodic pata.
It is mentioned in Annex 1.
You have taken me to page 18, isn't it?
Yes, that is impugn order.
So now you're coming telling me
Yes.
the facts of the case. You
Yes.
have a periodic pata.
My lord. Yes, paranam
758 of 1986.
758 of 76. Yes.
You are having this period.
Yeah.
So where's that periodic pata?
Annex 1, page number 11 in memo of appeal.
Okay, you have this periodic pata.
Yes.
It's valid up to?
Yes, as per 2016, 22/11/2016.
Okay, valid up to 2016. Then you were having this. Then what
Yes.
happened?
My lord,
Where's
in the
this
year
place?
1998, appellant submitted complaint to the respondent number 3 regarding
1998.
my lord regarding encroachment of my lands by the respondent number 4 herein. And And as per that, as per my complaint, necessary action was taken by the respondent number 3. That can be seen in Annex 2, page number 8 of somewhat like paper book herein. Although paper book is not prepared, but
Where's that?
I think
Page?
it will be page number 10.
10.
Yes. Order passed by the settlement assistant settlement officer, who is respondent number 3.
Page 10 is something different.
Page number 10 and 11. Annexer in the annexer 2.
Annexure 2.
2, yes. In the main suit, civil suit number 81 of 2011. By the order of this honorable court, I made photocopy of the main suit and served to the parties.
So Annexure 2A, is it or what? Annexure?
Annexer 2.
Annexure 2 here is the judgment of the court
My lord.
dated 2510.
My lord, in this bundle, civil suit
Which
number
bundle?
81 of 2011, page number 10, annexer 2. The same
Wait,
has
wait,
been
wait,
placed
wait,
by
wait.
me by the direction of this honorable court.
By the?
By the direction of this honorable court, my lord.
So where is it? It should be here.
Yes, I duly given copy.
CMA,
My lord,
CMA 8,
my lord, no.
2011, is it this?
That one is
See, this is, what are you referring to?
civil suit number 81 of 2011. This copy has been photostated by me and served to the government site as well as private respondent, and for copy also this of this honorable court
So where is it?
by the order of this honorable court.
So where is it?
I think 3 or 4
Anything
years back.
3 or 4 years back.
Yes. I made this photocopy by the direction of this honorable court. LCR has been called for and
Then it
received.
should be a paper book.
Yes, but by the order of this
Dated what? Order of this court dated?
why not? It is a bit difficult to have.
It is in a copy of the opinion. I saw Children Council and shall furnish the civil copy of the plain civil suit number 81 along with an extra within 1 week. This is case after 10 days.
I did it within time.
See, this is what we have. Let's see if we can be on the same page. These are the documents we have. If it's not available, then you'll have to. I've seen the judgment of this court, copy of the plaint, etc. But if it's not with this court, you'll have to see. If what you're referring to, is it?
Yes, this.
What happened? It's not there?
It is not here. Oh, as thick as this one.
So you make another copy, you give it to the thing with the proper cover and everything. Is it there?
If it is not available, it is my duty to.
So you provide a copy, we'll list it some other day. When will it be ready? If we cannot be on the same page, we cannot consider the
Yes.
matter, isn't it?
Yes, madam. I'll do it.
Heard Mr. Laldam Flonga. Oh, call them. Is it with you?
It's with me.
Then
I
how
have
was it
the
not with the court?
civil suit, eviction suit. What that belong? Yeah.
This court's order dated 14/08/2020 says that it is seen that no paper book is prepared and the appellant had not annexed a copy of the plaint as well as the written statement to the appeal memo. As such, the learned counsel for the appellants shall furnish the learned government advocate copy of the plaint, okay, civil suit along with the annexures and also the written statement filed the defendant within a period of 1 week. So you did that,
Yes, I did.
but that copy is not with the court.
That copy also was given to the government advocate also.
Government advocate, it's a different matter.
Yes, yes. At
But
the
now
time when
the
I-
court will have to have a copy of the same, isn't it? Which is not available, it appears.
Yes.
So, but Mr. Laldam Flonga, learned counsel for the appellate. Along with Mrs. Mary Elkiante, learned counsel for the respondent, is it?
The state respondent,
Five,
State respondents.
yes. State respondent and respondent number 5,
private
14,
respondents.
16, 17, 20,
State,
21 and
learned
23.
government advocate for the state respondents who submits that she will also be representing the private respondents in the instant appeal. It's done.
Some of them, Your Lordship, not all of them.
Okay, be representing the private respondents number. Give me
5,
the numbers.
14, 16, 17, 20, 21, 22.
Okay, write down the list and give it to her. Okay, private respondents number so and so. Full stop. It is seen that though the learned counsel for the appellant had
Written statements.
prepared copies of the plaint in terms of this court's order dated 14/08/2020. The same is not available on record. In view of the above, the learned counsel for the appellant to take steps for making copies of the plaint prepared in terms of this court's order dated 14/08/2020. What is the sentence? Just read. And make it available for the record of this court. List after or in the next week? Will you be prepared by the next week?
Yes.
Okay. List this matter in the next week. You want a fixed date or no?
I'm not available on Friday, Your Lordship, next week.
So list in the next week. So it will come up for the hearing in the next
Yes,
week.
yes.
Anytime when both of you are present and everything is there, we can have the hearing. Yes, list.